Steve is one of my favorite Midwesterners outside of my family. He comes from Chicago. He moved here about 2 years ago, having found his own law firm and worked there for 16 years, practicing complex commercial litigation. Since moving to Austin, he started his own mediation practice. He's very diverse and has lots of interesting things to talk about. I always leave our conversations with some bit of curiosity and information, and I always enjoy every sort of interaction that we have. So he has a great podcast. The last 2 episodes, he's been talking about COVID and mediation during COVID. I'd encourage you to listen to that if you want to learn some more about his thoughts on mediation. He can talk to you about greyhounds and Bulgaria and definitely about baseball. So he's going to talk to us today about, can mediators and attorneys be biased? So, and I'm sure I left a million things out, but welcome, Steve.
Thank you. Well, thank you, Maricela, for those kind words. This is the 3rd time in the last few months that I've presented on cognitive biases and mediation, and each time I've tried to tweak the presentation to match the particular requests from the association. The first time I did this was down with Alyssa at the Central Texas DRC. They wanted a 2-hour presentation, so we tacked on a discussion about the mediation program for surprise healthcare bills. Just last week, I focused more on the valuation of insurance coverage cases when I made a presentation to the insurance section of the Chicago Bar Association. So if you can't tell from my accent, Chicago is where I'm from, born and raised, and where I practiced law for the last 25 years. So in talking with Michelle and Maricela about this presentation, I think there was a request to talk a little bit more, perhaps, about some ethical questions, and so hopefully some of the tweaks and additions that I've done to this presentation should satisfy that. So we're going to talk about different biases, and I talk about biases both of the heart and the mind. You know, some biases are for better or worse, people might have preconceived notions that impact all of their thought process with respect to a certain type of person. I talk about biases of the mind. We're going to talk about ways that people sometimes make mistakes in their decision making, and how we as mediators might be able to try to help that. So I'm going to try to provide some suggestions for how mediators might address certain of these situations. And like I said, we'll talk about some ethical considerations as well. So there are many types of biases that are common and unfortunately plague our legal system. And mediators need to try to recognize them and assess how it impacts our job. So it's 2020 still, and so I think that means we're contractually obligated to at least reference COVID. And as you all know, courts are struggling right now with balancing safety protocols and carrying out justice. A lot of courts are all virtual, but most are trying to figure out how to return safely to live trials. And I've talked with and I've read articles from judges and attorneys around the country about how they can do this safely, but still allow the jury to assess the credibility of witnesses. And invariably, to the judges and lawyers involved, this means having protocols that permit witnesses to testify live without wearing a mask. Why? Well, the assumption is we can't trust this guy in the slide, right? We can't trust a masked witness. And in fact, our entire legal system is premised on allowing juries and trial judges to assess a witness's credibility. Appellate courts are required to defer to a jury's assessment or a trial judge's assessment of the demeanor of a live witness. Here in Texas, it violates a criminal defendant's constitutional rights under the Confrontation Clause to allow a witness to testify with a disguise that covers up too much of their face. So the system is premised on the assumption that people can tell from nonverbal cues whether someone is lying. And it turns out study after study rejects this premise and concludes that the average person, like your average juror, is just not very good at trying to determine who's a liar just by looking at nonverbal cues. So a shameless plug here. I did one of my podcast episodes with UConn law professor Julia Simon Kerr about masked witnesses. And her take was she was hopeful that COVID provided us with this opportunity so that courts would actually permit people to testify wearing a mask, and that it would be more common for jury instructions to include a reference to the science that says that jurors should pay much more attention to the substance of the testimony rather than trying to figure out whether the person is telling the truth by looking at nonverbal cues. And so a spoiler alert here, on the podcast, I told the professor that I thought she was probably being a little naive, that centuries old systemic assumptions in our system might be eliminated overnight, even if the science doesn't support them. So the specific bias at play here is we all have stereotypes of what a liar looks like. We might be sweating, poor eye contact, fidgeting. That's what a liar looks like. But someone who calmly makes good eye contact and tells you sincerely what they're saying is the truth is somebody who fits our preconceived notion of what somebody should look like who we're going to trust. And I think in the last few years, the system as a whole has started to realize that there are systemic biases, that even though it sounds neutral to say that people think that they can tell what a liar looks like, it's impacted by cultural and racial stereotypes in terms of what they think somebody should be looking like and comparing it to a witness who is testifying. So it's above my pay grade and outside the scope of what we're talking about today to get really into the weeds about systemic assumptions. But the point is, this is a type of bias, the bias that we can understand who's lying and who's not, despite the fact that science really doesn't support that, that impacts the system. And so how does that affect, mediation? I think something we all tell people, we're mediators, we're not judges. It's not our job at a particular mediation to try to root out between two conflicting stories who's telling the truth and who's not. But I found that I might say something like, again, verifying, it's not my job to pick who's telling the truth, but I've heard different stories when I'm with you and when I'm in the other room. And all I can tell you is that the other side presents a risk to you because the way they present themselves is in a manner that a judge or jury might accept as truthful. And I found in family law cases, and for those of you who know me, I took the family law training with Maricela and Stea, and I consider myself still a novice when it comes to it. But oftentimes in those cases, I think being empathetic to somebody that I understand you're telling me and you fully believe that the other side is lying on something, but when you talk to them about litigation risks that a jury or a judge might believe them, a lot of times in family law, they'll acknowledge that, because nobody goes into a marriage thinking that they're going to get divorced. And you often hear people say, I know she or he sounds believable, but I'm telling you that's not true. And so all I'm doing is, by suggesting that our entire system is sometimes impacted by the bias that we can tell who's lying and who's not, is something that mediators can do to both be empathetic, allow people to, tell us their side of the story, but also, frankly, to stress to them that they do face litigation risks, that a judge or jury might agree with the other side. So let's talk about biases that can be held by mediators. I mean, clearly a mediator is not allowed to discriminate, right? Now, I know some of you are lawyers and some of you are not. And as lawyers, we all had to take the bar exam, which is a test that tests the substantive laws of a particular jurisdiction. We all have to take what's called the MPRE exam, which is a multiple choice exam. It applies more nationally, and that's the ethics part of the bar. And anybody who's sat through the bar exam and have gone through bar review courses learns all types of ways to remember different things. And I've got a friend who still teaches a bar review course, and I asked him, I said, do they still say that lawyers are not a bus? And he said, yeah, that's still something that is used. And the point is that lawyers, unlike a bus, are not required to pick up passengers at every stop. They're generally allowed to discriminate. At least they're allowed to discriminate because they don't have to take a client who's not going to agree to pay their hourly rate. They might be a family lawyer and know nothing about securities law. And so they're allowed to decline those type of cases. And we mediators, we're in the same boat. We're allowed to turn down cases if the compensation isn't agreed. And we might turn down a case if it's a subject matter that we're not familiar with. But what about, can a lawyer or a mediator discriminate based on a protected classification? Race, gender, national origin, sexual orientation. It turns out this is actually a little bit of a trickier question. Now, first of all, lawyers and mediators provide services. And the law is, to some extent, unsettled on whether you can discriminate in providing those services. You might remember a few years ago, the Colorado wedding case. Now, that went to the Supreme Court, Masterpiece Cake Shop. And in that case, a Colorado baker refused to make a cake because it was ultimately going to be used at a same-sex wedding, and the baker said that violated their religious principles. Colorado said that was unlawful discrimination. The Supreme Court overturned that ruling, but on very narrow grounds. They determined that the Colorado Human Rights Commission had made anti-religious remarks that colored the entire assessment of the case, and so they remanded that. In other words, the Supreme Court punted from answering the big question, which is, could somebody, based on their religious beliefs, deny a service that they otherwise would be willing to do to other folks? So, kind of like my lead into systemic issues with racism and how we look at witnesses, the purpose of this presentation isn't to go into the weeds on discrimination law. But you should know that federal law, like the Civil Rights Act of 1964, that bars discrimination in places of public accommodation. So you might not think of it this way, but whether mediation applies or not, at least for federal anti-discrimination laws, could depend on the nature of the mediation. If the parties contacted you directly and it's a confidential private mediation, that probably, although not definitively, would not be considered a public accommodation. If you're on the wheel of the Travis County mediation cases, or you're otherwise doing a court-ordered mediation, then technically there's a better argument that that's a public accommodation and federal law might apply. Now, some states have much broader anti-discrimination statutes. I did do a commercial matter that was governed under California law, and California has about the broadest anti-discrimination law out there. So if you're doing mediation in other jurisdictions, you might want to look into what their law is. Now, again, this isn't exhaustive, but I'm aware of 2 cases that have said that lawyers might not be buses after all, because they both found that lawyers could not discriminate. In Nathanson versus MCAD, a Massachusetts case involved a lawyer that specialized in mother's rights. So she only represented the wife in divorce cases, and she wouldn't represent a man. And this was a very clean case. There wasn't mixed motives. She admitted, she said, look, my business model is I represent women. I'm not going to represent him because he's a man. The Massachusetts court found this to be a discrimination against a protected class. The interesting thing about it is this was decided about a decade ago, and it really, if you shepherdize it, it has not been cited otherwise, but it's out there. There's also a Tennessee formal ethics opinion that found that a lawyer who was part of a system where he was accepting juvenile clients that needed help, and the particular juvenile client that was assigned to him sought his assistance to get a waiver for consent for an abortion. And he refused to represent this person because it violated his religious beliefs. And the Tennessee ethics opinion, like Massachusetts, found that that's discrimination. And both Tennessee and Massachusetts rejected the notion that was presented by both lawyers in this case, that they couldn't do their job. Lawyers have to zealously advocate on behalf of their clients. And so both the Tennessee and the Massachusetts lawyers said, we can't fulfill those ethical obligations due to our personal beliefs. And both the Tennessee and the Massachusetts courts said, no, you have to separate your personal beliefs, and even though you don't believe in it, as a lawyer, you can still represent a client who wants something or has different values than you. So again, those are only 2 cases. It's not at all clear that that's like even anything approaching a majority rule. But let's assume that that was a majority rule for lawyers. Should that logic be applied to mediators? Now, first, I understand I'm a lawyer, so I'm subject to ethical rules and regulations, both for mediators and lawyers. But let's take that to one side and talk about whether mediators should be subject to the same rules. Let's say that I am Muslim and I believe that it's improper. I have the belief of the sect that believe it's absolutely improper for anyone to charge interest on a loan. And I do mediations through the Central Texas DRC, and Alyssa asks me whether I'm ready and available on December 19th. I say yes. I show up, and it's a bank foreclosing on a loan that has interest, and I tell Alyssa and everybody else that I can't do that mediation due to my religious beliefs. Is that something we should allow mediators to do? Can they discriminate on that basis? So the Texas ethical guidelines for mediators, as you all know, say that they're only aspirational. Although if you join certain organizations like TMCA, you're agreeing to abide by them. So Rule 9 talks about impartiality. A mediator should be impartial towards all parties. And then the comment to Rule 9 says that if that impartiality has been compromised, the mediator should offer to withdraw from the mediation process. And the comments say that impartiality means freedom from favoritism or bias in word, action, and in appearance. So in my opinion, I think this rule demonstrates how mediators have a different role than lawyers. Lawyers, frankly, are a cog in the system. They're supposed to zealously advocate on behalf of their client, but ultimately the judge or the jury is going to determine their client's fate. Now, we as mediators are not judges, but we do set the tone and control much about how a mediation is conducted. And so we don't myopically only represent the interests of one party. We have, as this ethical guideline shows, committed to all parties that we are going to be impartial. So to me, it means not only, frankly, that mediators can discriminate by suggesting that they're not going to do the case that involves the foreclosure because they don't believe with that they actually should and that they must. And if you can't be fair to that bank, then the rules should not require you to mediate the case in the same way that Texas and Massachusetts told those lawyers that they needed to represent those clients. So in other words, in my opinion, it's mediators, not the lawyers, that are the real buses. And as Maricela pointed out, if we went back to that other slide, it was a Greyhound bus. So, but this is not I'm trying to highlight how I think that this should be looked at. I am no means saying it's definitive. There have been some scholars out there who have taken both sides of the argument. And so for devil's advocacy, I could point out that Texas, as you know, has not adopted the model guidelines for mediation ethics. And frankly, those have some of the comments that I referenced about bias and withdrawing that are in the comments to Rule 9 in the Texas ethics. They're more up front and center and in the actual rules. Moreover, you could argue that the comments to Rule 6 of the Texas ethics, which requires a mediator to set out the basics of mediation by saying it's private, it's informal, and confidential. It doesn't say you absolutely have to stress your neutrality and impartiality. So you could make an argument based on the text and comparisons that maybe in Texas, if, and it's a big if, the law was developed that in providing services, even lawyers would be forced to abide by anti-discrimination laws, that it could apply to mediators. But I think on balance that mediators, unlike lawyers, if they are self-aware and they recognize a bias, should not be forced to mediate cases that they know that they can't be neutral. So one of the first things that I realized in becoming a full-time mediator is the different perceptions of mediation between litigators and mediators. You take a look at these pictures, and I can tell you lawyers definitely think the mediator is the one drinking the foo-foo drink, okay? They're the ones, the lawyers are the ones that are doing the heavy lifting, and mediators, all we want is for people to hold hands and sing Kumbaya. In fact, a lot of lawyers would think a discussion about cognitive biases is a bunch of mumbo jumbo and not an integral part of their job. And this isn't just my anecdotal observations. The ABA section of dispute resolution had a task force that asked attorneys and mediators about what role a mediator should play? And not surprisingly, the answers were very different. For example, 84% of attorneys thought recommending a specific settlement, the mediator recommending a specific settlement, would be helpful, whereas only 18% of mediators thought the same. 75% of attorneys felt it was appropriate in some cases for a mediator to apply pressure on a party to accept a particular proposal, while only 30% of mediators agree. Many lawyers are just completely unaware of mediators' legitimate concern with evaluative mediation, and that mediators are always concerned to make sure it's the self-determination of the parties to voluntarily come to an agreement that can't be violated. So in light of this disconnect, I have a pre-mediation call where I tell the parties that my personal style is to employ analytical techniques, including reality testing questions and generalized opinions about litigation risks for both parties. And I do that so that I can ask them whether they're comfortable with that. And overwhelmingly, they have agreed. But if they want it to solely be a facilitative mediation where I don't involve those type of questions, then we can have an agreement at the start. And so I think that that has helped create realistic expectations for everybody from the beginning. And it's a recognition that even people that we think might be thinking the same that we are, that different attorneys might have different biases about the mediation process itself. Now, in commercial matters, both sides ultimately calculate a value for their case. And this involves making predictions about the future. Now, unfortunately, people are just not as good in assessing risk and misunderstand often basic probability. There's numerous academic studies that have analyzed trial results and the last settlement offers that have concluded that parties and attorneys frequently make decision errors. A study by Professors Gross and Siverud found that plaintiffs reject a more favorable settlement offer in about 65% of the cases they looked at. And defendants, on the other hand, decided to go to trial in 25% of the cases in which they would have been better off settling. So let me make myself clear. I find the definition in some of these studies of a decision error to be problematic. And frankly, ironically, for what we're talking about today, to be emblematic of what's called an outcome bias. If I'm a defendant and 100 of the world's greatest lawyers unanimously agreed that my chance of winning a case was 95%, and you had a stubborn plaintiff who was only willing to give you a 5% discount for settlement, otherwise you'd go to trial. Well, regardless of whether that defendant wins or loses at trial, I would argue that it's not a mistake to reject that settlement demand. The system itself makes mistakes too, which is something we as mediators often stress to parties. The purpose of my raising this study is just to point out that many people are unhappy with litigation, the results of litigation. And we tell that to parties all the time as mediators, that in hindsight, they often wind up rejecting a more favorable settlement situation than trial. So whatever quibbles I might have about whether these are mistakes or not, I think it's very clear that lawyers and parties can do a much better job at assessing risks and valuing their cases. So today we're going to talk a little bit about some common mistakes that lawyers and parties make in valuing their cases and some of the cognitive explanation for them. And I know we have, mostly mediators here, so I want to stress that, like for a CLE, for this type of presentation, I understand it's okay for me to lecture a little bit, but that I'm self-aware and I understand that as a mediator, that's far less productive. Our jobs as mediators are not to independently come at a value for a case and tell the parties that's how they should resolve it. So that's not why we're talking about these potential errors. But I think that your understanding of some potential ways that people might not be thinking accurately about a value of a case can help you ask questions so that you can make sure that all parties have considered all the angles before they reject settlement opportunities, walk away from the bargaining table, and go to a trial that study says they might not be very happy with. Now, when I was in college and in law school, the prevailing wisdom was that humans acted rationally and in their own financial self-interest. And if they didn't, it was usually explained by distortions in the market. There was imperfect information. That person just wasn't aware of certain facts. But another discipline has gained a lot of steam: behavioral law and economics. And that's devoted, frankly, to why humans often make bad decisions. And it explicitly recognizes that some of the decisions that people make are made on gut impulses and feelings that are just not accurate. Nobel laureate Daniel Kahneman, in his seminal book, Thinking Fast and Slow, notes that in order for humans to survive and make everyday decisions, the thousands of decisions that we're confronted with every day, we have to develop heuristics or shortcuts. And that's okay if we're not fully processing all information, if we're deciding which gas station we should fill up our tank in. That's okay. It's a little less okay when we're talking about assumptions that might impact parties' decisions in whether to settle or not settle litigation. So in my pre-mediation life, as Maricela said, I was a commercial litigator for about 26 years. And I'd often be sent cases by clients and asked to evaluate them. And I have a vivid recollection of one case where I provided my analysis of the situation for them. And we had a conference call, and there were multiple representatives from my client on the call. And universally, they all decided to call me Glum from Gulliver's Travelers on the call for the rest of the time. And that's an uncomfortable feeling for a lawyer, because lawyers know, on one hand, that they need to provide objective legal advice to their client. But they also know that they run a risk of angering their clients, telling them something that they don't want to hear. And this phenomenon permeates the attorney-client relationship. And it's been described as a conspiracy of optimism. One book that talks about this and other biases, Litigation Interest and Risk Assessment, is one of the more recent books on sale at the ABA dispute resolution. So that's something, if you're interested in any of these topics, feel free afterwards. I'm going to reference a couple books and articles. I'd be happy to give you information about that. But in general, they know that parties tend to overvalue their cases. And frankly, even in the first meeting between an attorney and client, the client, if they're maybe embarrassed about some facts, they might sugarcoat the situation in eliciting advice from an attorney. On the other hand, an attorney in that first conversation is more likely to focus on positive facts to demonstrate that they've made the right choice with this lawyer, that this lawyer is going to zealously advocate on their behalf. So that just shows us that it can become a cycle, and that's an explanation for why, when we get to mediation, sometimes parties are a little overly optimistic of their particular case. Now, many of you might be familiar with the term anchoring. This is a picture of a rug of one of my best friends. He bought this, I think, over 20 years ago in Istanbul, Turkey. And he came back to the United States very impressed with his negotiation skills, because the initial price for this rug was thousands more than he ultimately paid after hours and hours of haggling. I think he met the salesperson's family. He ate Turkish delight. He drank Turkish coffee. And to this day, he's not only both happy with his purchase, but he's clearly subject to the cognitive bias of anchoring. And in negotiations, anchoring is frequently the obsession of a plaintiff's opening demand. Now, studies show that anchoring is real. There's one famous study where people were asked to spin a wheel with random numbers. And then afterwards, they answered a completely unrelated question, like how many countries are there in the United Nations? And the result of the study was your answer of that question is completely dependent on the number that came up when you randomly spun your wheel. So once people, for whatever reason, think about a particular number, and usually in negotiations, it's the plaintiff's opening number, then they can be anchored on this. And I can tell you, I did a lot of defense work, and I would say, oh, I never was anchored on that. But ask some colleagues who are lawyers if they settled a case where the original demand was outrageous, and they settled it ultimately for a lower amount. I will bet you that when they write the final report to their client, they remind their client how high the initial demand was. And it shows you that that number is living somewhere in your brain. Now, there are a lot of techniques that defense lawyers use to try to avoid anchoring. But I'd like to stress that anchoring isn't only a plaintiff's initial demand. I think perhaps even more importantly, it can reference each side's initial evaluation of the case. So some cases get resolved earlier. I admit the type of complex commercial litigations that I worked on typically would go on for years. And over the period of time that they're going on, the law could change, the facts could change. You might find in discovery some good documents or depositions. And so your original assessment needs to be altered. But too many times in settlement, parties get hung up on their initial evaluation. Frankly, once that changes, your initial evaluation is irrelevant. And in a perfect world, all parties will be analyzing the new facts. So as a mediator, I always try to find out as much as I can about the process that parties went through in developing their valuation of the case. When it was done, how it was changed, who calculated it, when it was approved by management. All of this information, I believe, can help you determine and think about whether a party might be unduly anchored to an initial position. And it might help you in asking questions so that they can maybe understand that while they think they're reasonable because they've altered their assessment based on new facts, that frankly, if they never had made that initial assessment, their assessment of the value of the case would be different than what they're suggesting now. All right, so this is a little bit of a warning because we might be entering slightly the math portion of the presentation. Parties in a commercial manner, dollars and cents, when they're trying to value their case, typically calculate the expected value. And the expected value of the case is the amount that is at stake. What could the plaintiff win? Multiplying that by the likelihood of success of winning. So let's say there's a $10 million case. Plaintiff, if they win, they get $10 million. If they lose, they get nothing. If we assume that they have a 50% likelihood of success, then the expected value of that case is 5 million. Now that seems easy enough, but what about in the real world when you have multiple defenses and issues? So according to the same book that I just referenced, mathematically their suggestion is that you multiply the likelihood of each defense together. So in other words, they're treating legal defenses like multiple coin flips. Mathematically, the odds of 2 heads in a row is 1 in 4 because you take 1/2, multiply by 1/2, and you get 25%. Now, if we take a look at the slide I have 2 defenses. Plaintiff is most likely to win the first defense 80% of the time, second defense 60% of the time. So both of these defenses aren't the greatest defenses in the world. But when we multiply it together, the plaintiff's likelihood of success is 48%. So the defense actually has a slight edge here, 52%. And so this is something you have to be very careful when you're calculating the probability of success in a case, is because if you multiply multiple defenses, then the defense looks to be in a very good situation. In fact, if we added a third defense that only had a 30% likelihood of success for the defendant, 70% likelihood for the plaintiff, collectively, when you multiplied it together, the defense's cumulative chance of winning one of those 3 defenses would now be 67%. So because of the way that it works when you multiply these together, we have to be very careful, because one of the biggest mathematical errors in legal matters is not recognizing when factors are not independent. Now, to be fair to the authors of Litigation Interest and Risk Management, at the very end of their book in an appendix, they make the same point, but I would have liked to have seen it actually earlier in the book. And that is, are the factors that you're looking at independent? Well, who's going to make the ultimate decision? Is it the same judge? Does the judge have a pro-plaintiff bias? Well, if the judge does, it doesn't matter that the facts and the law around defense 1 and 2 seem on paper to be independent, because if you have a common decision maker, then they're not independent. I do find it interesting in Travis County, the way judges are assigned and don't live with cases. You can have certain issues decided by different judges in a way that's very unusual. Throughout the country, usually a civil matter will have preliminary rulings held by the same judge. So maybe that bias in Travis County is less of a factor. But it doesn't have to be nefarious, like, oh, the judge has a bias. It also could go to, is the same witness going to testify about facts in support of defense 1 as in defense 2? If so, and that witness is great, and the jury's just going to love that witness, then the defenses are no longer independent. So this can be serious stuff. Another book called Math on Trial talks about the case of Sally Clark. Sally Clark, unfortunately, had 2 of her children die of sudden infant death syndrome. And this was over in England. And Sir Roy Meadows developed a theory called Munchausen syndrome by proxy, a form of child abuse where the parents invent medical issues in their children. And Dr. Meadows made a career of testifying that a whole bunch of British mothers were ruthless murderers who were killing their babies. And his main evidence was statistics. He testified in the Clark case that the likelihood of a cot death was 1 in 8,543. And so he said the likelihood of that happening twice to the same family was 1 of 8,543 times 1 out of 8,543, or 1 in 73 million. The jury determined that Miss Clark was guilty of murder. The appellate court affirmed. and she served 3 years in prison. Now let's try to think about this for a little bit. First of all, the basic assumption that you would just multiply the probability of death of one child with the second child is completely incorrect in this situation. Why? Because there was no effort to rule out genetics. So if we're talking about the two children of the same couple, it's possible that they aren't just independent, but that there's factors that make the unfortunate resolution more probable. Now, what turned out is, at a further look at this case, the second child died of an infection, something completely independent, and was missed the first time. So like I said, Miss Clark served 3 years in prison, and ultimately, when she was released, within a year, she committed suicide. And she wasn't released until the Royal Statistical Society started to urge courts to disregard Dr. Meadows' testimony. So math can be extremely important if misused in our legal system. I also think that this shows that people misunderstand unlikely events after the fact. Winning the lottery is very unlikely, yet people win the lottery. But our brains are wired sometimes to try to explain why a very unlikely event happened. So in negotiations, when parties say something like, oh, there's a 10% chance that this happened, be careful, because a lot of times they're saying that, but what they're really thinking is that's just not going to happen. And so lawyers, parties, and mediators need to be careful not to minimize completely unlikely events. They're unlikely, but they do happen. All right. Now, when I did this in Hayes County, this was a shameless plug for my website. So I see you smiling, Lissa. I'm not going to pull up my website. If anybody wants to, they can go to it at showoffmediation.com. You can play a game called Resolution Roulette. Now, what Resolution Roulette is, it's a rip off of the old Let's Make a Deal, the Monty Hall game. So for those of you who remember Monty Hall and that game show, Monty had 3 doors. 2 doors had goats, and 1 had a car. Now, Monty knows where the car is. He asks you to choose a door. After you choose the door, Monty then reveals a goat behind one of the remaining doors. And then Monty, because he's a magnanimous game show host, now gives you the opportunity of a lifetime. He says, do you stick with your original door, or do you stay with your original door, or do you switch to the other door? So the fundamental question to this game show is there a correct answer? Should you switch? And the answer is yes. Mathematically undeniable, the answer is you should always switch if given the opportunity. And if that doesn't seem correct to you, you're not alone. The Monty Hall problem has confounded people for years. When Marilyn Savant, who reportedly had one of the highest IQs in the world, answered her column in Parade magazine by saying that you should switch, thousands and thousands of people wrote into Parade magazine saying that she was crazy. Moreover, many of the people had PhDs in mathematics. So why talk about the Monty Hall problem? Why do I have it on my website? And again, feel free to visit, play it as often as you'd like. Well, the Monty Hall problem is more than a tricky math problem. It helps underscores how humans often make poor decisions. So let's first make sure you understand why you need to switch. The key is fully appreciating the rules and their impact on future events. Hopefully, we can all agree that when you made the initial selection, there was a 1 in 3 chance that you selected the door with the car. Now, most people, though, intuitively conclude that once Monty reveals the goat behind the other door and there's only 2 doors remaining, that they have a 50% chance of winning. Unfortunately, that's not true. So let's try to understand why. Remember, Monty has to show you a goat. So let's assume that you pick door number 1. Now, instead of focusing on door number 1, let's focus on the doors that you didn't select. Monty has to reveal a goat. It's not random. He can't reveal the card. So in 2 out of 3 scenarios in which you select a goat, one of the other doors has a goat, one of the other doors has a car. Monty can't show you the car, so he's showing you the door with the goat. In 2 of those 3 situations, he's telling you the unopened door has the car. So therefore, you double your likelihood of success if you switch. Now, numerous studies cross-culturally, different countries, different socioeconomic classes present the Monty Hall problem, and almost universally, 90% of people turn down the opportunity to switch, even though your chances are increased if you do. So the problem is the Monty Hall problem is tricky, yet it seems simple. And I think an example I used on this is if you stumbled into Elon Musk's control room during a launch of a SpaceX rocket, and his go-to engineer all of a sudden became ill. And he looked around and he pointed at you and he said, damn it, Bill was supposed to calculate the orbit coordinates and beam them up to the cockpit. Can you do me a favor? Can you do that? I think most of the people on this Zoom call would say, hell no, are you crazy? I can't do that. But there's something about the Monty Hall problem that when somebody asks you whether you want to switch, your brain is telling you, hey, there's only 2 doors. We've got this, no problem. I'm able to make that decision. But unfortunately, in order to make the decision to maximize your likelihood of winning, you have to pay close attention to the rules. Now, saying that from a mathematical perspective is that you actually need to understand a little bit about conditional probability, specifically Bayes' theorem. Now, like I said at the beginning of this, I've done this presentation a couple times, and what I've learned is we're not really going to talk about Bayes' theorem very much. The slide is up there, but don't worry, there won't be a math pop quiz. And clearly, I'm not suggesting that parties need to understand conditional probability or Bayes' theorem to settle cases. I'm not even saying that they have even needed to have heard of Bayes' theorem. But what the Monty Hall problem shows is the dangers of underestimating the difficulty of calculating even what looks to be simple probability. And so some of the things that we're talking about today is, in Daniel Kahneman's terms, trying to help people slow down so that they can fully appreciate how to deal with case value. So Maricela, you were right. I got my greyhounds into this presentation, and I'm sure that most people would think that looking at sleeping greyhounds is much better than looking at math formulas. But we've shown that the Monty Hall problem demonstrates that, well, people might be worse at math. But that's really not the only reason that I'm talking about it, because something else is at play here. Like I said, 90% of people see no advantage to switching, and therefore they stay. Okay, but if you believe that there's no benefit to switching because it's a 50-50 proposition, then why don't more people switch? This shows that it's not only that they're missing the math point that it's an advantage to switching, but there's an emotional component for their decision making. Now, according to studies, Um, and, and if you think I'm going to beat this to death, there are full books on the Monty Hall problem. Jason Rosenhaus wrote a very good one. And in it, he talks about how people feel worse if they affirmatively take an action and get a bad result than if they just passively wound up with the identical bad result. So his book has this example of two scenarios. You own $10 of stock in company A, and you're thinking about selling it and buying stock in company B. So there's two scenarios. The first is you sell stock in company A, you get stock in company B, and company B goes bankrupt. You lose your $10. The second example is you never got around to selling your stock and company A goes bankrupt. Either way, you're out the same $10. But uniformly, people feel much worse if they affirmatively sold the stock, even though it has the identical result. Now, Keith Law, in a much more readable book about baseball, The Inside Game, talks a lot about these biases and notes that if you're a baseball fan, you ever watched a game and you couldn't understand why your favorite team's manager left the pitcher in too long, he suggests it's the same way, that managers would rather be passive than affirmatively make a decision for which they can be second guessed. So in an article appropriately entitled Monty Hall for Dummies, Maroney and Fiore set out to determine whether there was something other than math at issue in the Monty Hall game. So what they did is they eliminated anything about conditional probability. So instead of, after you selecting a door, Monty opening another door, Monty immediately says, how about this? I will trade you the two doors you didn't select for the one you did. Now, clearly, you don't have to know anything about conditional probability to realize two doors is better than one. And most people do switch, but still, 15% of the people refused to switch. And the authors felt that this had nothing to do about math and was merely a psychological response based on the status quo bias. So I think this can have an impact on settlement discussion, because we've all been at mediations where both parties recognize that they each need to make a move, that they're far apart, but no party wants to be the first one to make a move. And I think the way that we handle this is something that you've heard from many other people, and I'm sure you all do yourself. It's very important, and this just underscores it, for us to project optimism. Because if people feel that their affirmative moves are a part of the solution, they're more likely to make them. If they fall prey to being overly concerned about the mediation failing, then they're much less likely to make a move, because they've resigned themselves to a situation in which they don't get the result they want, there's no settlement, and they passively did that. They can go back to the office and say it was the other side's fault. So that's just something to think about in terms of the dynamics, in terms of how we as mediators can get people motivated to try to get beyond their status quo bias. Now, another bias at play here is that people tend to overvalue what they already have, and they bend new facts to support their conclusion. And this is called the endowment effect. A famous experiment was run by Kahneman, where he gave people mugs that were sold at a store for $6. He gave that to them to then negotiate with a third party. And he wanted to know whether people would come to an agreement at $3. They'd split the difference of this gift that was given to the parties. Well, it turned out that once these people got their mugs, they tend to value them higher. And the sales price was closer to $5. So let's go back to the Monty Hall game. I think people tend to focus on and overvalue what they already have. Once you select door number one, it's no longer door number one, it's my door. And we start processing information in a way to give us positive reinforcement. So Monty opens the other door, shows us that there's a goat, and your mind goes, yes, that means now it is only two doors. But no, as we talked about, we knew Monty was going to open a door and show us a goat. So we learned absolutely no information about our selected door. However, we're ignoring that we're learning valuable information about the doors we didn't select. Because as we discussed in 2 out of 3 of the scenarios, we now know that the car is behind the unselected door. So one thing that I try to do is if I'm in a case, a commercial case in which the parties are calculating valuations, I always ask the parties to try to calculate how they think the other side is calculating the case. And a lot of times parties have already done that. But what I don't think that they do is once things change, once they're considering new law, new facts, and they're willing to change their valuation of the case, asking them to do that from the other side might show them that, oh, while they recognize that this fact isn't great for them, thinking about it from the other side's perspective really makes them understand why the other side now has taken the position that they have. So trying to avoid the endowment effect is a way that we can move past biases. So as I said, you can go to my website and play resolution roulette multiple times. And people have had studies where they've asked people to play the Monty Hall game multiple times. And Herbershon and Schroeder concluded a study that said that when pigeons were given multiple opportunities to play the Monty Hall game, that they begin to act rationally and figure the game out more quickly than human beings. There's a follow-up study by Stagner and Zentel that disagreed only slightly, noting we found that pigeons performed only slightly better than humans, but adding further insult to injury, found that rats and humans learned the Monty Hall game at about the same rate. So does that have any application to mediation? No, but like I said, I've done this a couple times now, and I think that I can say is what people actually remember a little bit about the presentation webinar. But one study that does show something that we can learn about is that an illusion of control can also be a factor. If a different person initially selects a door, and then a second person is asked to stay with the door that the other person selected or switch, a much, much higher percentage of people switch. And so this again underscores the psychology evolved in this decision making. And I suggest it does present an opportunity, albeit a tricky one, for mediators. You know, I previously said I like to learn as much as I can about how a party is thinking about how they're valuing the case. And part of that is who actually did the calculation? Was it the attorney? Was it the client? And based on what we just talked about with illusion of control is, I think naturally the party that came up with the calculation is less likely to deviate from that calculation than the other side. And so again, I said that this is tricky because we as mediators it's not our role to drive a wedge between an attorney and a client. But it is good to know and maybe to direct some questions to see whether perhaps the author of a settlement analysis or valuation might not be the party who would be willing to compromise. So that's something that I think has a practical application for mediation. So if it's not abundantly clear by now, there's been numerous studies about how people are thinking related to the Monty Hall problem. So this slide shows some different ways that scholars were trying to determine, what was people's thought process. And there's a study by Shimojo and Ichiwaka, and also a study by Ruma, who basically determined that this first one, the number of cases theorem, when the number of possible alternatives is n, the probability of each is 1 over n. In other words, they're equally probable. And that's how people are thinking about the Monty Hall problem. Now, Falk notes that this is, for whatever reason, a very strongly held conviction, and it often is resistance to other arguments and logic. And she suggests that explained why so many PhDs were writing into Parade, magazines, saying that Marilyn Vos Savant was wrong. It was because of the way that people are wired to think about probability. So let's try another problem. Mr. Smith has 2 children. At least one of them is a boy. What is the probability that both children are boys? So you might tell from the run-in here that this problem isn't necessarily what it appears. The vast, vast majority of people say it's an equal probability that the other child is a boy. And that's incorrect, because we need to think about this in pairings. There's 4 possible pairings. You could have 2 boys, child 1 is a boy, child 2 is a girl. The next alternative, child 1 was a girl, child 2 was a boy, or 2 girls. Well, we know that Mr. Smith didn't have 2 girls, so we eliminate the girl-girl situation. And in the remaining situations, in 2 out of 3, the second child is more likely to be a girl. Now, this, according to Fox and Lvov, only 3.3% of MBA students with statistics training answer this one correctly. And this, just like what we were talking about with Monty Hall, shows that the equal probability bias is a strong heuristic that leads to judgment error. One of the interesting things for mediators is that some people think that these heuristics can be solved by framing. So Fox and Ronnenstreich asked participants of the study to estimate the probability that Sunday will be hotter than any day next week. They also asked people the following: the hottest day of the week will be Sunday. When presented the first way, Sunday or the rest of the week, people tended to look at it as 2 equal probable events. When the question leads people to realize there's actually 7 days in a week, then more people recognize that and realize that Sunday, being the warmest day of the week, is much less likely. So they suggest that, at least in part, some of the deficiencies that we have in probability can be solved by framing. And as mediators who potentially can ask questions to parties, that can be valuable information. Another thing that has been done to help people understand the Monty Hall problem is, if the game is presented with the same rules but 100 doors, and you're told Monty is going to reveal 98 goats, so that at the end there'll be 2 doors remaining, and you're given the opportunity to switch, 95% of people switch. Now, if you think about it logically, the rules are really the same. But what people submit is going on is that people understand that their original selection only had a 1 in 100 chance. So the endowment effect is not that strong. They don't value it that much. But in a 1 in 3 chance, people can convince themselves that the new information now means that they should stick with the choice. The interesting thing about this study, in my mind, and it goes back to the rats and pigeons, is they did this study with 100 doors, then they switched it back to 3 doors, and even though 95% of people switched when they had 100 doors, and even though they were being asked right after that, that the results were consistent with all other studies. 90% of people wound up keeping their initial door. So Burns and Wheat suggest that the real reason that the Monty Hall game is hard is something they call the collider principle. They suggest that what's going on is that people fail to understand the causal structure in the problem. So in the summertime, both murder rates and ice cream consumption increase. But it'd be a mistake to say that there's any correlation between murder rate and ice cream consumption, or at least I hope so. So if you take a look at the slide, that's why the arrows are going away from summertime. They're not colliding with summertime. But let's take another scenario. Let's assume there's 2 reasons that your car might not start. Your battery is dead or you don't have gas. Now, clearly the amount of gas you have in your tank is wholly independent from how your batteries operate. But once the common effect is known, there's a conditional dependency. So if your car doesn't start and you learn that your battery is good, then you now know you're out of gas. The 2 factors are conditionally dependent. And because of the way it's charted with the arrows going in, it's called the collider principle. So the Monty Hall game is a collider principle, but it's harder to recognize in the car example because the answer in the car is deterministic. And in the Monty Hall, it's only probabilistic. Your chances are more likely to select the car if you switch, but not absolutely certain. So Burns and Wythe changed the Monty Hall game to Fight Club. So no, really, they decided to run a test where instead of doors, there were boxers. You were told that the boxers would compete and the more skilled boxer would win. You selected a boxer and there was a fight between the other 2 boxers. The better boxer won, and you were given the opportunity to switch from the boxer that you selected to the boxer that prevailed. In other words, it's the same conceptually as the Monty Hall game. The result, most people switch. And the conclusion that the authors have is that they switch because people recognize that if skill was involved and it wasn't just random, that they were more likely to change their initial selection based on new information. So I would submit at mediation that also has a role here. If people think that things have changed totally fortuitously, they're more likely to dig in on their valuations than if you can subtly try to bring out things that have happened during the course of a case that might be based on skill. So I know we're up against time here. I think the one Lord knows if anybody had questions. The next thing I was going to talk about was that base rate is very important. I can talk to anybody who's interested in this, but again, it's just more ways that people do not accurately perceive biases. So one real quick way to tie this all back in is what ethical constraints, if any, are there on a mediator who recognizes that perhaps a party or their attorney are misunderstanding probability? And I would suggest in looking through most of the ethical rules on mediation is that mediators do not have an obligation to point out to a party that they might be calculating something incorrectly because of a bias. I think if there's a simple 10 plus 10 error, that's a different story. But I think that all of the things that I've raised about biases are ways that you can use to try to have people reconsider their thought processes. And as mediators, we never want people to walk away from the mediation table, from the bargaining table, without fully considering everything. So from an ethical standpoint, I don't think it's a situation where a lawyer knows that maybe somebody's wrong with the law. I think it's more akin, it's more akin to a situation where it's not even a material fact. It's something that's out there. It may be impacting somebody's thought process, but I don't consider it part of my job to make sure that people have fully considered whether their probabilistic assumptions are accurate in settling, unless it's something egregious. So that I know I short-circuited that, but I know Michelle wanted me to both start and end a little bit on ethics. So that's my one attempt. We've switched a couple things, but in conclusion, I think as mediators, we can help people think slow. That people need to, in valuing cases, use math and logic and not your gut. You need to be careful about being anchored to your original case assessment. And one way to avoid doing that is, as mediators, maybe to ask people to calculate probability from the other side's perspectives. A lot of what we're talking about is you can be blind to certain facts, and that's a way mediators can help, making sure everybody is considering all of the facts. And sometimes, I didn't talk about this in a lot, but reframing percentages in terms of relative strengths makes people stop thinking about percentages. And a lot of the biases here, the mistakes in calculations, have to do with misunderstandings of probabilities that sometimes you can talk through if you talk about how many times out of 10 are you going to win something, as opposed to saying what's the percentage likelihood of success. So those are some tips. I know I can talk about this forever. I appreciate everybody bearing through this with me. And if there's any questions, I'd love to stick around and talk with folks.
Michelle, I know that someone asked about the name of a study. I'm sorry, I forgot which study that was. Do you remember?
Joseph had asked. Joseph, can you let Steve know the specific study you were asking about?
I don't remember either. It was the first one.
Well, let's see. Was it the one related to the fact that plaintiffs and defendants turn down settlement opportunities? Okay, so admittedly, there's some nepotism there. That study was by two Michigan law professors, my evidence professor and my insurance law professors, Professors Gross and Syverud. Syverud is Syverud. They've actually done multiple studies on that, and there's been some follow-up studies as well. So I think the punchline there for mediators is it's a different way to remind people what we always try to tell them, which is, a lot of times people are disappointed with the results of litigation, so they should really think about settling.
Mm.
Okay, are there any other questions?
Linda, I just saw that somebody had another question, maybe about like a book or not. So I'll stick around just if somebody did have that. Was it Joseph? Was it you again?
It was me again, fellow lawyer and
no, that's fine. Look, I appreciate it. So it was the ABA book?
Yes, sir.
Okay. It's called Litigation Interest and Risk Assessment. It's by Michaela Keet, Keet, Heather Heaven, Heavin, and John Land, Lande. Last I saw, it was still being pushed. If you remember the American Bar Association dispute resolution section, it's the latest book that they put out.
Okay. Thank you.
No problem.
All right. Thanks, everyone. And we'll see you next year.
It was great.